Hi, my name is Bridget and I'm the Conveyancing Manager here at MMLaw. I'm going to talk to you today about the new seller disclosure regime which comes into effect on the 1st of August. If you're a property owner, real estate agent or buyer, the new mandatory seller disclosure regime is something you need to know about. The Property Law Act 2023 replaces a nearly 50-year-old legal framework that governs property transactions in Queensland. One of the most significant reforms is the introduction of a standardized disclosure statement regime for sellers of residential and commercial property. This change aims to make the process more transparent, reduce misunderstandings, and it avoids disputes between sellers and buyers down the line. So what exactly do sellers need to give buyers under the new law? Before the buyer signs a contract, sellers must provide a Form 2 seller disclosure statement, which is a prescribed form, along with certain prescribed certificates and information. Some examples of prescribed certificates include a current title search and survey plan, an owner-builder notice under the QPCC Act if the seller carried out work as an owner-builder at the property and there is a note on title in this regard, any applicable contaminated land notice, show cause or enforcement notice, resumption notice, neighbourhood disputes, for example, tree orders and applications, transport infrastructure notice about proposals, and pool safety certificates or notice of no pool safety. For strata-titled properties, body corporate documents, which include a copy of the community management statement and body corporate certificate. Some examples of prescribed information includes details of the seller and the property. For strata-titled properties, details of the body corporate. Any unregistered encumbrances such as unregistered leases, residential tenancies, access agreements, oral agreements, and statutory encumbrances. Details of any existing tenancies if the property is rented out, environment or heritage listings, zoning and local planning info, and up-to-date rates and water information. And importantly, these documents must be accurate and current as at the time that they are given. While buyers don't have to sign the disclosure statement, it's best practice to get this confirmation of receipt. This applies to all residential and commercial property sale contracts signed on or after the 1st of August 2025, irrespective if the property was listed before this date. There are a few exceptions, such as transfers between family members or sales ordered by the court, but in most cases, the regime will apply. So what does it mean if you're buying a property? You'll know more about the property up front before signing anything. You can review legal, planning, and some financial documents early in the process. If the seller fails to disclose something important or gets it wrong, you can potentially terminate the contract before settlement. The changes give buyers more power to avoid nasty surprises, such as discovering too late notices under the Building Act against the property, which could force a buyer to spend money on the property, planning issues, or some other hidden costs. It also shares the cost of property searches and inquiries a bit more evenly between the parties. Buyers should also be aware that the disclosure statement does not cover everything. For example, it does not cover information about flooding or natural hazard history, structural soundness or pest infestation, building or development approvals, and that includes whether all structures on the property have been issued with final council approval, asbestos presence, and utility connections. Buyers are still encouraged to conduct their own due diligence, including building and pest inspections, flood searches, plan-in checks, and searches on any other relevant matters. Here's the kicker for sellers. Non-compliance can cost you the sale. If the disclosure is missing, incorrect, or misleading, the buyer can terminate the contract at any point before settlement. Even if everything else is going smoothly, an incorrect disclosure could bring the whole deal crashing down. And that means lost time, lost money, and for agents, lost commission. So what should sellers and agents do? First of all, start early. Don't wait until you've found a buyer. Gather your disclosure documents well before listing. Secondly, get expert help. Work with experienced property lawyers to prepare the disclosure statement. And thirdly, stay updated. If your property stays on the market for a while, make sure your documents are reviewed and updated regularly. At MMLaw, we understand how overwhelming these new requirements might feel. That's why we offer a tailored service to help you and your clients navigate the disclosure disclosure process accurately, efficiently, and with peace of mind. Whether you're the seller, a buyer, or a real estate agent looking to protect your transactions, we're here to help your sales run smoothly and to make sure no disclosure issues puts your deal at risk. Thanks for watching. If you found this video helpful, please consider giving us a like, subscribe to our channel, and share it with anyone who might benefit. Take care, and we'll see you in the next one.